Good afternoon. Happy Friday. For those of you who missed my live stream yesterday, I came to the conclusion that Chille's not going to win on his appeal to the, was it Clark County District Court in the misdemeanor case that he got convicted of. Depends on if I remember to or not. I might kind of go over the high points of it just in case you did miss the live stream. But upon further reflection, I think that Oram is even smarter than I thought. Oram, for those of you who don't know, is Chille's attorney on the appeal portion of the misdemeanor case. So he's got paid 25 grand. He's made one bail appearance. He made one special appearance for Chille in another hearing in the other misdemeanor case he has in the actual municipal court, not the justice court. He may or may not have prepared briefs for the bail hearings. And then I don't think that he prepared, or at least other than maybe cutting and pasting it onto his pleading paper, I don't think he wrote any of that garbage that I went over yesterday. That had all the hallmarks of Chille's legal team on it. Maybe some help from him, or maybe one of his paralegals or something. But that was amateur hour. That was not, an attorney didn't prepare that. Oram could not have practiced that long as he's practiced, and not know how to do a basic appeal on something this simple. So that had to be amateur hour. He didn't prepare it. But he's getting paid 25 grand allegedly to do that little bit of work that he's done. I don't even think he's going to have to go do oral arguments. I think this is going to be denied based on the moving papers. So it's a good deal for him. The long and the short of it, though, is I doubt seriously that he wrote the moving paper, because the form of the argument was incorrect. Now, I'm not saying there's only one way to write. It's not like math where, you have to do 1 + 1 = 2. It's not exactly like that, but it's similar. The argument would be essentially, for this kind of thing, would be conclusion, rule, analysis, conclusion. The conclusion is that the trial court erred in something, or the conclusion would be that this particular statute is overbroad. Chille might have been trying to make that argument. I don't know, but I kind of get the feeling he was trying to make an overbreadth argument, either face on its face or as applied. But so it'd be like for sections 1 and 2, which I can't really detect a difference in. He was making arguments that don't make any sense. Like, press, freedom of the press. Well, what the fuck does that mean, dude? Like, show me a case that deals with this that is even remotely applicable to what you're doing. But regardless, it would be conclusion. This statute is overbroad on its face. Rule, a statute is overbroad if, and then on its face, a statute is facially overbroad if it captures protected speech in it. If it makes illegal protected speech, right? Analysis. So here's how you look at it. The Nevada Supreme Court has developed this checklist essentially to determine whether or not a statute is facially overbroad. And then conclusion, the statute is facially overbroad. And then you start off your next portion, conclusion. The statute is overbroad as applied. The rule is if a statute as applied catches your speech, if your speech was protected, which I think is really what Chille was trying to argue, that his speech was protected. If a statute criminalizes your speech, then as applied to you, the statute is overbroad. Analysis. Bleh. The Nevada Supreme Court or the Nevada Court of Appeals or whoever has determined that this is the checklist for being overbroad as applied. You can see it in, what was that? State versus Wilson, or Wilson versus State, whatever it was. You could see how they applied these kind of things to one of the two statutes that Chille was charged with. So you go through that checklist and then the conclusion again. And then you go into vagueness. And it's not vague and ambiguous. Vague and ambiguous is an objection you would make in discovery. And who's been doing a lot of discovery? Chille, or Chille's legal team. So instead of saying, this is void for vagueness, he said, this is void. Or no, he said this is vague and ambiguous. An attorney wouldn't do that, but Chille would. So then again, you do conclusion, rule, analysis, conclusion for that. And you go down through it. And again, some of the things are really stupid, like saying that attorney me, the attorney who represented Chille in the trial, saying that it was ineffective assistance of counsel because attorney me failed to serve and file his motion or his briefing on the First Amendment. Well, so the problem with that is that in order for that to be ineffective assistance of counsel, number one, you have to plead why it would have been had he done this correctly, it would have changed the outcome of the case. Well, we've gone through the First Amendment above, right? And if Chille doesn't prevail on the First Amendment part above, then why would he have prevailed if attorney me had filed and served this preliminary motion correctly or preliminary briefing correctly on the First Amendment? Well, he wouldn't have. So if you prevail on the First Amendment issues, then you win and Chille goes home. If you don't prevail on those, then the ineffective assistance of counsel would also have failed, because you're saying that he would have briefed the First Amendment, but the court would have just ruled that you lose on the First Amendment. So what he did not affect the outcome. You see what I mean? It's stupid. Like, why would you even plead that? The only part that makes sense in the ineffective assistance of counsel portion to plead, the only part that makes sense is where he alleges that attorney me failed to get admitted into evidence the video recordings that Chille made on the day of the arrest. Which sounds great, but the only issues that Chille raises is saying that those videos would have shown that he was at least 10 feet away. Congratulations. He laid out in his statement of facts that everybody agrees that Chille was 10 feet away. Even the officer said Chille was about 10 feet away. Congratulations. You don't need Chille's video to prove that. So if he had introduced Chille's video into evidence about that, it wouldn't have changed anything. It would have just confirmed the testimony that already was in evidence from both the officer and from Chille. It would have confirmed that Chille backed up. Congratulations. Everybody already testified that Chille backed up a few feet. It wouldn't have changed it. He has not pled anything in the appeal that would suggest that if attorney me had in fact introduced that video into evidence, that it would have somehow changed some fact that is necessary, some element that was necessary for conviction. So it was a giant waste of time. It had all the hallmarks, all the stink, all the weird formatting things and failures that you've come to expect from Chille's pleadings. It had all of those. So I strongly suspect it was a brief that was prepared by Chille and just signed by Oram. For those of you who can't imagine why an attorney would do that, well, $25,000 is a huge incentive to do that. And if your client's like, no, I want to do the brief, and you're like, well, fine, you're going to lose anyway, so I might as well let you do the brief. Now, what happens, I almost said if Chille loses an appeal. What happens when Chille loses an appeal? Well, he's only got a couple options. In Nevada, you can appeal a municipal court or a judicial court decision to the district court. And that's where it stops. Now, a district court decision, like if you go to trial at the district court level for a felony, then you can appeal that to the Nevada Court of Appeals, which is a fairly new layer in Nevada. And then from there, you could potentially get a writ of certiorari to the Nevada Supreme Court. Potentially. But you can't, if you start off in the municipal court or in the justice court, the highest court for you to appeal up to is a district court. Chille can't appeal the decision of that district court to the Nevada Supreme Court. He'll never get there. He won't get there. Every time someone has petitioned for a writ of certiorari to the Nevada Court of Appeals or to the Nevada Supreme Court from a decision of the district court, an appellate decision of the district court, looking at a lower level trial ruling, municipal court or justice court decision, the Nevada Supreme Court has said, no, we don't have jurisdiction. It ends at the district court level. So where does he go and how does he do it? Well, he's got two real options. Number one, he can appeal or he can file a petition for a certiorari to the United States Supreme Court. Good luck. Not happening, not in a million years. Not only do the facts not support you, not only does the law not support you, not only is there not a First Amendment issue in this, or a Fourth Amendment issue, or any other fucking issue, but even if there was, the odds of the Supreme Court taking your petition for writ are infinitesimally small. So, what do? Can you appeal this decision at that point if the Supreme Court decides not to accept your petition for writ of certiorari? No, appeals are done. So what could he do? Well, in theory, he could apply to the district court, the federal district court for the District of Nevada. He could file a petition for writ of habeas corpus. Now, would that be successful? Not having read it, I'm going to say probably not. And the issue is, would he even be able to do that in time before he's already released? Probably not. Probably not. Would that affect the ability for him to petition for habeas corpus? File a petition for writ of habeas corpus? Yeah, it would. Because he would no longer be held. So it's going to be a real problem. I mean, I don't know how he intends on resolving this, because I think he gets out in like August, right? It was like for 6 months, but like for some reason the math didn't add up to 6 months. It was like August or October. I don't remember which. But either way, I don't think that it's going to be resolved. I don't think that he's going to have an opportunity really to do the petition for writ of habeas corpus to the federal district court. Yeah, I just don't see it. So anyway, he doesn't have a lot of options, and for those of you who think, for any idiot attorneys out there who think that he's going to be able to appeal this to the Ninth Circuit, you're a fucking idiot. And this is why I don't listen to other attorneys on the internet. Thanks for watching. Have a great day.